Good afternoon, welcome to EduSet Network. Friend, as you know, today we are going to discuss important topic. The topic is imperative of Constitution of India. Imperative means requirement, a special attention, what is required. There are several imperative and requirement of the Constitution of India. The Constitution of India is a comprehensive document. It sets out not only the nature of the state but also boundary. So we'll try to understand the different aspects of it, and particularly with today's lecture, we'll try to understand the imperative for the bigger section, what the provision has been given in the Constitution of India. And for discussion on this very topic, we have in studio an eminent faculty, Dr. Rajveer Sharma. He is a senior academician, author of several books. He keeps writing on national, international journal, various topics, and authored many books. And he has been also engaged in writing for the different, as you said, journals and international journals. But apart from this, his work on the urban governance has been well appreciated the world over, and he is also the member on the various board of the universities across the country, and been worked as, invited as a guest faculty or visiting faculty from India and also from abroad. So certainly his knowledge and experience will help us to understand this topic and will give insight how to study the imperative of Constitution of India. So on your behalf, I welcome him for EduSet lecture on this very topic. Welcome, sir.
Thank you, Sinha Sahab, and very good afternoon, viewers. As you have been told that we are here to discuss today a very significant issue of the imperatives of the Constitution for the welfare and development of the weaker sections. In fact, the broader topic of the imperatives have a multi-dimensional kind of an issue. The social, political, administrative, cultural, meaning a comprehensive kind of treatment has been given to different aspects of governance and democracy in the country by the framers of the Constitution of India. It has been rightly described by a number of scholars in India as well as abroad that Indian Constitution is a social document. In fact, it is being said that Indian Constitution, if implemented correctly and effectively and efficiently, can re-engineer the society. In a way, therefore, we can say that Indian Constitution is an instrument of social re-engineering. It can be a tool of social and economic reconstruction of the society as a whole. Particularly in the context when we became free and there were, the large scale disparities of different types, social disparities, particularly based on caste discriminations, economic disparities and inequalities, characterized by the concentration of wealth and the national resources in a fewer hands, and the elitist character even of administration. In order to overcome these disparities, the framers of the Constitution provided for certain specific arrangements to address the problems of poverty, the problems of deprivation, the problems of the exploitation, and this very purpose and goal of the Constitution was revealed by them in the preamble of the Constitution itself, where it was said that India shall be a secular, socialist, democratic republic. It would be a sovereign state. In a way, therefore, they laid down the basic foundations of the goals and nature of the Constitution. But the provisions further in the preamble of the Constitution also made it very evident that the state shall aim at providing a social order where there shall be equality of opportunity, of status, there shall be an assurance of dignity of the individual, there shall be an assurance of the freedom of speech, faith, expression, and there shall be a provision for justice, social, economic, and political. I think if we read these provisions of the preamble of the Constitution, it would be very evident that the framers of the Constitution were not only conversant with the ground realities prevailing at the time of the framing of the Constitution, but they were also very clear in their mind about the nature of the society which India should strive for in the years to come, in the future India. And it is in this context that I would try to understand as to what were the concerns of the framers of the Constitution with regard to the development and welfare of the weaker sections of Indian society, and how therefore we can justify the statement that Indian Constitution is a social document or it is an instrument of social re-engineering. Let me begin with the fact that the basic objective of the Constitution, aiming at the development and welfare of the weaker sections, are contained in several provisions of the Constitution. And the basic postulates that emerge from the Constitution are A, the establishment of an egalitarian society, an egalitarian system, the removal of the social and economic inequalities. Particularly, it aimed at ensuring the society which is based on the equals. That is, the purpose of the fathers of the Constitution was to send a message to those who were to acquire the responsibility to govern, that they must make efforts consciously, deliberately, to create a society of equals. And when we say that they should strive for a society of equals, it means that they first of all should strive to put an end to the system of exploitation of man by man, which was quite deeply entrenched in our system before independence, particularly during the colonial regime, based on caste systems. And friends, let me tell you that several provisions of the Constitution did aim at social equality or the society of equals. Article 17 of the Constitution, which is a part of the fundamental right to equality, can be cited as one of the examples where we could have left this issue to the wisdom of the legislatures or wisdom of the political executive, but we did insert this provision in the Constitution so that it is clearly the responsibility of all the organs of the state, legislature, executive, and the judiciary and also of the society to put an end to social discrimination based on caste. And I think you know that Article 17 relates to untouchability, which was a part of our social practices, and this social practice was in fact a social evil which differentiated between man and man on the basis of his birth rather than giving equal treatment to all people as human beings. And it was out of this provision of the Constitution that Indian Parliament enacted the removal of Untouchability Act, which is of course is now an offense. Practice or propagation of untouchability in any form, we all know, is now a punishable offense. Now the purpose of this is clear, therefore, that we must work for an equal system where everyone has a status, not on the basis of birth but on the basis of his human existence. Similarly, the society of equals can also be inferred from Article 18 of the Constitution of India. Well, we also can refer to another kind of an institution where it was aimed at that there should be some efforts to set up a system where all institutions of national life must be informed by the requirement of establishing a just social order. I think if we go to Article 38, which is a part of the Directive Principal State Policy, then it would be very clear that the framers of the Constitution made it incumbent on the state to promote a social order which is based on justice, social, economic and political, and this justice-based society, the social order, shall be promoted by all the institutions of national life, including the institutions like legislature, executive and the judiciary. If we proceed further, Article 39 of the Constitution is again an imperative for the policy makers that the policies of the state shall be so framed and shall be so directed that it leads to the equitable distribution of national wealth, meaning that economic justice should be a road to equality, should be a road to put an end to exploitation, should be a kind of effort to enable every section of the society to stand on their own. And therefore, right to livelihood, right to legal aid under Article 39A, and several such provisions, particularly the equal pay for equal work, they formed part of the emphasis of the Constitution of India. Some people might say that directive principles in fact are not a binding force. Constitution cannot be, these provisions cannot be enforced by the court of law, but the fact of the matter is that nowadays the judiciary is taking recourse to the directive principal state policy even while interpreting the fundamental rights contained in the Constitution. Several fundamental rights have been interpreted by the judiciary in such a way that they are in fact the extension of the scope to include the directive principles of state policy. For example, if you look at Article 45 of the Constitution or Article 46 of the Constitution, I think we know that Article 45 and 46. Article 45 of the Constitution refers to the free and compulsory education, right? And the judiciary has interpreted this provision of the Constitution to be a part of right to life. They say that right to life, in fact, cannot be thought of in the absence of the right to literacy, the right to education, because right to life in fact implies right to life with dignity, right to live with dignity, right to live with knowledge, right to live with some kind of capability to interpret the world for oneself, to understand oneself, to acquire capabilities and skills, to create and participate in the opportunities to earn for themselves, which is the basis of right to live with dignity. And that has been the part of various judicial judgments. Right to health is nowhere in the initial scheme, was nowhere included in the directive in the fundamental rights. But the judicial interpretation has included right to health in the fundamental right of Article 21 of the Constitution, that is right to life. Similarly, right to freedom also has been interpreted to include right to information. The point which I am trying to emphasize here is that the directive principles may not be enforceable directly by the judiciary, but they remain fundamental in the formulation of policies. They are the fundamental for the state to be taken into consideration while framing the policies, and if there is a need for extension of those fundamental principles, they have been included in several judicial interpretations in the scope of several fundamental rights. Therefore, I think even the issues of free and compulsory education and right to health, which have a direct implication for the weaker sections of the society, have become an integral part of the right to life. Now, at the same time, we also know that right to livelihood, right to food security, right to safe environment, right to safe drinking water, I think they also have the implications for the quality of life of the people in general and also for the weaker sections of the society. Equality of opportunity and status. Now, this provision of a guarantee of equality of status and opportunity has been provided in Article 16 of the Constitution. And when we say that every person shall have the right to equality of opportunity, Article 16(4) at the same time makes some kind of special provisions for the welfare and development of the scheduled castes, scheduled tribes, other backward classes. Similarly, Article 46 of the Constitution also makes it incumbent on the state to promote with care. I underline, it is the duty of the state under the directive principle state policy that state shall promote with care the educational and economic interests of the weaker sections of the society in general, but the interest of the scheduled castes and scheduled tribes in particular. Now, therefore, if we look at this issue of equality of status and opportunity, this also implies that it is a provision which has very wide implications and has wider scope for itself. And it is here I would like to repeat that equality of status and opportunity is difficult to be conceived, is difficult to be imagined in the absence of the right to education and right to health, right to work, and right to get assistance. I think even here I would like to draw your attention to the fact that the Constitution under the Directive Principle State Policy do provide for social assistance, for special assistance. To whom? To those who can really be termed as weaker sections. A, it talks of social assistance to the old age persons. B, it talks of the social assistance to the disabled people. C, it talks of the social assistance to the widows, and so on and so forth, meaning those who really are unable to help themselves at one or the other stage of their life are to be considered as the part of the responsibility of the state to be helped. And I think you know that it is flowing from this provision of the Constitution that in India we have launched a number of social assistance schemes. For example, there is an old age pension scheme. For example, there is a social assistance for widows scheme. And for example, there is a family benefits scheme. Now, these social assistance schemes are being framed under the obligation of the Constitution that is prescribed in the Directive Principle State Policy. Further, the protection of the interest of the working population, the labor, the workers, is also a part of the responsibility of the state. And this kind of the responsibility also has been provided that the worker should not be forced by any kind of circumstances to work in an unhealthy situation, in unhealthy conditions of service, meaning thereby that the protection of the interest of the labor at the workplace and to provide them the congenial work environment is the responsibility of the state. And out of that also there have been several legislations that have been enacted by the government at the center and also in the states to protect the interest of the labor, both in the agricultural sector, industrial sector, and also commercial sector. The workers working in different areas have been protected under several laws, whether it is BD Workers Act, whether it is Factory Workers Act, or it is the Child Labor Act, and so on and so forth. Now, besides these provisions in the Constitution, in the Directive Principles, there is also a provision for the protection of the women, and particularly the provision for maternity assistance and maternity health to the women, that is also being provided in the preamble in the Directive Principal State Policy. Now, when we talk of the other weaker sections, specific weaker sections, let us come to the children first. Not only that, the children are being sought to be protected under the Directive Principal State Policy in terms of health and nutrition and a special care for them, but the fundamental rights also refer to the special efforts to prevent the exploitation of children. I think if we read Right Against Exploitation, then it becomes very clear that a special reference has been made to the protection of children against employment in hazardous industries or in any kind of avocation which hinders their development and growth as a productive human resource. And it is out of this that several laws have been enacted by the government, by the central government, and to enforce this welfare measures. The Abolition of Bonded Labor Act was passed. Now, this act to abolish bonded labor has its grounding, has its foundations in the right against exploitation. That is, forced labor is prohibited under under the right against exploitation, and it is also a guarantee against exploitation of the compulsions of labor or the poorer sections of the society. Now, therefore, the one form of forced labor was bonded labor, and you know that we deliberately and consciously took this decision to abolish the bonded labor. Only a note here, and that is that Bonded Labor Act, though was a welcome step, but still a lot remains to be done insofar as the achievement of the goals underlying this act are concerned. One, that is still the practice of bonded labor continues in several parts of the country, and the administration has not been able to completely implement the provisions of the Constitution to put an end to the practice of bonded labor. And secondly, the system of bonded labor still continues because of the poverty in which the weaker sections and the poorer people find themselves in. In fact, until unless the people who have been freed from the bonded labor are provided with adequate supports in terms of skills, in terms of training, in terms of financial help, perhaps it would not be possible for them to remain free. They might be free, but they will not be free for all times to come until unless they are provided with required capabilities and capacities to remain outside that circle of bondage. So this forced labor practice requires a special focus on creating economic abilities for those who are economically disabled and also socially disabled. Now, proceeding further, there are certain sections in the provisions of the Constitution. For example, we have taken special care to not only provide for special arrangements in terms of policy and law, But it was also a concern of the fathers of the Constitution to see that these policies and constitutional provisions and laws are enforced, monitored, reviewed, and assessed from time to time on a continuous basis. And for this, they thought that there should be some institutional arrangement. Article 338 of the Constitution creates a mechanism for the protection, advancement, enhancement, promotion of the interests and the rights of the scheduled castes and scheduled tribes. All those who have been students of the Indian political system must be aware that Article 338 provides for the national machinery for the protection of the interest of the scheduled castes and scheduled tribes, and under this the special machinery we have created the National Commission for Scheduled Caste and also the National Commission for Scheduled Tribes. Friends, let me tell you that both these commissions were provided in fact with a view to review the policy, law and administrative machinery meant for the promotion and protection of the rights and interests of the scheduled castes and scheduled tribes. These commissions are having the powers of a civil court, and as a institution with powers of civil court, they have a right to call for any kind of evidences, papers or files, even the documents that might be with any ministry, department or even the judicial institutions. It can also compel the people to appear as a witness if required, and if the person required to be a witness fails to appear, then like a civil court, it can also issue the non-bailable warrants. It has also a right to therefore examine the witnesses on oath. Now, besides that, it has several other functions, whether it is the National Commission for Scheduled Castes or National Commission for Scheduled Tribes. It may not be possible to deal with the entire role in details, but let me tell you that this commission also has been vested with the power to review the laws or the policies and also suggest the new measures that should be taken for the advancement and protection of the interests so that social justice can be promoted. The objective is that these sections should be provided with justice, social, economic and political. Now, besides that, that we created a constitutional machinery for their protection, we also thought that perhaps the goal of equality, political, social or economic, which are integrated with each other, which are interlinked with each other, it is difficult to separate these concepts in a watertight system, that these goals of social, political and economic equality may not be achieved until unless the scheduled castes, scheduled tribes and other weaker sections are really empowered, and empowered not only socially but also politically. Maybe that political empowerment can further lead to social and economic empowerment of these sections of the society. Therefore, the framers of the Constitution, right in the beginning, provided for the reservation of seats in the legislatures and also in the civil services, right? The objective of reservation in the legislatures was that these sections of the society should be given a voice in determining the policies for the nation as a whole, and they should be enabled to attract the attention of the lawmakers to some specific legal measures required for the upliftment of the weaker sections. So therefore, they were supposed to develop the confidence, they were supposed to develop leadership qualities, they were supposed to be treated as politically equal, they were supposed to develop the skills of debate and articulation of social and economic matters of interest, and become an active participant in the governance system of the country. And the results of this constitutional arrangement are there for all of us to see. There has been a rise of the consciousness, political consciousness, in these weaker sections of society. There is a sense of the identity at one end, but at the same time they also have been able to reduce the social discrimination on the basis of caste. Perhaps it was this political empowerment of the scheduled castes and scheduled tribes that the gaps of the higher and lower castes could be minimized, if not eliminated. Now, later on, it was thought that the empowerment, political empowerment of these sections at the level of parliament or state assemblies is not enough. And particularly when we are saying that the social discriminations are taking place at the grassroots level, and it is the empowerment of these sections at the grassroots level which is also very significant. Particularly so when we thought that the local governments, whether in rural areas or in urban areas, should become the instruments of self-governance. In other words, the growing pressures for decentralization of governance, the pressures emerging for empowerment of the local communities, giving them the choice and the power to assert themselves in decision making. In fact, when we thought that local governments should be given the responsibility for welfare development at the local level, through panchayats and the municipalities, the municipal bodies, it was also realized that the weaker sections should be given a special say. Therefore, when we enacted 73rd and 74th Amendment of the Constitution, this objective was very much evident. Before that also, the Panchayati Raj institutions and the other bodies of local government had representation to scheduled castes and scheduled tribes and also for women. But this reservation for or representation of the scheduled castes or the scheduled tribes was more symbolic rather than real. And it was this kind of a situation that was sought to be remedied through the increased reservation for the scheduled castes and scheduled tribes. It is a known fact now that 73rd and 74th Amendment seeks to provide reservation to scheduled castes and scheduled tribes, and within them to the scheduled caste women and scheduled tribes women also, in accordance to the proportion of their population. For example, if in a village the scheduled caste population is, say, for example, hypothetically 80%, then 80% of the seats in the panchayat in that village shall be reserved for the scheduled caste. Similarly, if in a block the total percentage of scheduled caste is say 15%, then 15% of the seats in the panchayat samiti shall be reserved for the scheduled caste, meaning thereby that now the representation of the scheduled castes and scheduled tribes in the local self-government institutions is in accordance with the proportion of their population. And therefore, I can say that this is a very important step towards empowering the scheduled castes and scheduled tribes, giving them both voice and also choice. They are now the important partners in the development process, meaning that now they cannot be subjected to some kind of a discriminatory environment as such. Coming to women, even here the women were represented in a very symbolic manner in the local governments earlier. But now the 73rd and 74th Amendment in the Constitution, as enacted in 1992-1993, provided for 1/3 seats for the women of the Panchayati Raj institutions at any level, and including the offices in the Panchayati Raj institutions, and so was the case with the urban local bodies, meaning whether it was the questions of offices or it was the questions of membership. In both these areas, the women were provided with 33.3% reservation. Now, of course, as you all know, this reservation has been increased to 50% of women. Now, the point therefore is that it is not a question of merely providing reservation, it is a question of the objectives behind it, meaning that women are now being treated as equals, and they are being treated as equals in terms of their participation. Well, several states, even before this amendment was made, were already implementing the 50% reservation of seats for women. Though I can't claim that this reservation has really been able to realize the objectives and the goals for which it was enacted, particularly because of the social, cultural and economic constraints. Still, the state and the central government both together are striving that women become the fruitful participants in the decision-making process. Let me tell you that the concept of the absentee or proxy meetings, or the male members attending the meetings or conducting the affairs of the panchayats on behalf of the women members, has been addressed by the central and state governments, and now it has been made obligatory for the administrative machinery to ensure that the absentee or proxy kind of meetings or proxy elections do not take place. It will go a long way. In fact, several meetings of the chief ministers, the Panchayati Raj ministers have been held by the Ministry of Panchayati Raj at the central level to address this issue of Pradhanpati and what we call the absentee members of the Panchayat. Now, therefore, the purpose is that the women should also come with the confidence of equality and leadership. And I would also like to state here that there have been several success stories where women have proved very effective leaders in terms of bringing about the development of their respective villages, and they have become very active participants in the governing process at the grassroots level. Fatima B, for example, from Andhra, was even selected for the achievement for the award, international award for leadership in that area. So the empowerment, political empowerment, we think will also lead to cultural empowerment, will also lead to social empowerment, will also lead to economic empowerment. Though still I say that cultural constraints are very much there, which have to be overcome over a period of time as such. Coming to another issue, and then we would be summing up the entire kind of a discourse. And that is that we also aimed at introducing some kind of the rights to women, and particularly I would like to draw your attention to Article 44 of the Constitution and Article 40 of the Constitution that were provided in the Directive Principles. Purpose, of course, was to impart justice to women of all sections of the society, irrespective of their religion or their caste. Article 44 of the Constitution talks of the Uniform Civil Code. In fact, this Uniform Civil Code is a social provision rather than any other kind of a purpose of this article. And if it is a social provision, then it is an enabling provision. It also aims at intra-gender equality, and it also aims at giving equality to women with men in all sections of the society. Article 40 proved to be the instrument of the introduction of Panchayati Raj system in the country, though there was a pressure even at the time of framing of the Constitution that panchayats should become the third layer of India's federation, the third layer of the government. And in fact, if we refer to Gandhi's concept of village republic, then panchayats were a part of this system. But at that time, of course, they could not be created as a third layer, but we can say that panchayats and the urban local bodies need to be made an integral part of the federal polity. And if we make this an integral part of federal polity, it will also serve as an instrument of empowerment of the weaker sections of the society. In brief, we have said that right from the preamble to Article 338 and 3 and others, the weaker sections of the society have been given a special treatment in the Constitution in order to establish a social order in which every section of the society must have a claim for equality, justice, and freedom. The three very important principles of a democratic society. We cannot imagine democracy in the real sense of the term. We cannot have any substantive democracy in the absence of justice, freedom, and equality, which should be the claim of every citizen of the country, including the poor, rather more of the poor. Thank you so much.
Okay, it's true that with this provision and the certain steps and policy schemes started have helped in mitigating the problem of weaker section and putting them on equal footing. But at the same time, we find that the market intervention has created great economic inequality. So, how do you think that the provision which we have at present in the Constitution, will they be able to solve the economic inequality, or we need to take certain kind of amendments, some more provision we need to include in the Constitution? How do you see?
I think, Mr. Sinha, this is a very important kind of a question. And there are fears right from the beginning of the shift of our economic policies from the welfare economics to market economics. And some people started saying that India, in fact, is abdicating its role as a welfare state. And therefore, I must say that there is a need for having a constant watch over the operations of the market. Market has to be domesticated. You know, until unless we domesticate the market, meaning thereby that market must be adjusted and adapted to the local requirements and particularly the requirements of the poor.
Right.
And secondly, I must say that even though we are moving towards liberalization, privatization, globalization, but at the same time it can be both, the instrument of removal of poverty, particularly by creating more and more job opportunities, and the states by not abdicating its social responsibility. The state will have to perform its social role, and it is performing its social role, particularly in the field of education, health, sanitation, the self-employment programs and so on. There are several schemes, as we know, the rural development programs, nearly 200 centrally sponsored schemes are there which aim at the development of the weaker sections, whether it is the question of housing, it is the question of food, it is the question of distress, relief to the people. And so therefore, we will have to have a balance between market and the interest of the poor, protection of them.
So we can say that we are on the right trajectory.
We are, of course, we are. In fact, in view of the fact that completely it is not possible for the state in the present era to provide the adequate kind of supports, and therefore in this globalizing world, perhaps even the communist world is moving towards the market economy. Whatever remains are there of the communist world, though there is no communist world at the moment, but whatever remains, like China and so on, China is also proceeding very fast towards market economy. It means that market has come to stay, and market is proving to be one of the
market has to stay, that is okay, but market dominance has to stay or not. What is your opinion?
No, in fact, the market dominance in certain areas, particularly in the manufacturing world, will have to be accepted. But in terms of the, if we really want to improve the public sector, then also the entry of the market is a must. Particularly for competition, for quality, for governance, for openness, for transparency. Even in the government activities and government administration, we need to have the market system.
Okay. So, as we talked about the different aspect of the imperative of constitutions, and we also at the same time we have a number of amendments taken to improve the situation. So, are you happy with especially in case of the decentralization of power and Panchayati Raj? So the functioning of Panchayati Raj, you said that it has been made obligatory by the on the part of the officials to ensure the women participation and all this be fully be. So what when we go on the practical see the practical aspect, what is the lacuna still existing?
Well, Mr. Sinha, I think I would say that so far as the decentralization of governance is concerned, there has been still a gap between promise and performance. There is a gap between theory and practice. And if you permit me to say so, there is basically a hesitant decentralization. Hesitating decentralization.
Okay.
There is perhaps a feeling that the local leaders and local governments may not prove to be rivals, and that is why those who matter in transfer and devolution of powers to the local bodies, they are not really coming forward to transfer the functions, the finances, the functionaries, and until unless we transfer these three F's to the local bodies, they will remain merely agencies of the state government or of the central government. And still, the Panchayati Raj institutions are playing more as instruments of the state rather than emerging as the instruments of self-government.
So how long this hesitation to continue?
You know, there has to be some kind of a development of demand from below. And I must say that in this sector, the civil society must play a very significant role in creating awareness of the rights and duties of the Panchayati Raj leadership, in building up the capacities of the Panchayati Raj leadership, and until unless we create that environment for demanding for the devolution of powers, until unless the local leaders and the local people demand the devolution, the pressures required for devolution will be missing, and the system will continue. But you know, as the arrangements will progress, I hope that this demand-driven change, rather than supply-driven change,
Right.
in politics and governance at the local level will come.
Okay. So this we talked about in the context of India, and when we see the other developing country, or we say the neighboring country, how you see the picture, entire picture, the big picture?
So there's a worldwide trend to focus on decentralization of governance, and particularly it is being said that decentralized governance also is not only the instrument of openness and accountability,
Right.
but it would be closer to the people. And once the government is closer to the people, then it can be taken as a system which shall be forced to serve the interest of all people, including the poor. Worldwide also, if you look at the system of say Japan or China or even UK, there is a trend towards more and more decentralization of power.
Okay.
In fact, in UK, there is a trend towards new localism, and under this concept of new localism, there are Margaret Thatcher and other leaders of UK. They did attempt to decentralize governance. Similarly, in China also, the local government's institutions are being sought to be strengthened.
Okay. So, well friends, with this word we like to conclude the lecture. I thank all of you for watching the lecture, and on your behalf I thank Professor Rajveer Sharma for giving such an insightful lecture on this great topic. Thank you very much.